Congratulations, you are a homeowner. You've worked hard at your job as a preservationist, you saved your pennies, and bought a lovely little historic farmhouse with hardwood floors and pocket doors. Just as you're settling into absolute bliss in your new house, your neighbor decides he's going to start a pig farm. Yes, a stinky, noisy, muddy pig farm. He's going to use the pigs to eat trash from nearby businesses. Don't ask, he saw it in an episode of Dirty Jobs once. You don't want to have to deal with this. How are you supposed to live in your beautiful house now with all these stinky pigs? What about the potential loss in property values for you and your neighbors? You'll never be able to sell your home now. Besides, you don't want to. It's your house. After a long series of discussions with your neighbor, who just isn't going to budge and who, wow, really isn't a nice guy, you decide to go to court. But why is it that you can sue him? Because we can't use our property to the detriment of others. You can't do whatever you want, whenever you want, with your land. This is a society, after all. We have land use laws, things like nuisance, zoning, height restrictions, use limitations, health, safety, and welfare, that kind of stuff. And that's what I'm going to talk about in this section. In the context of the history and evolution of law, I'm going to talk about where the laws impacting historic preservation come from, the origin story, if you will. I'll address ideas like property ownership, how that right allowed us to regulate things like pig farms through nuisance law, which is justified by protecting the public's health, safety, and welfare. And I'll talk about how nuisance allowed the government to regulate aesthetics, which actually came into play as a justification for urban renewal, which you'll learn inspired the drafting of the National Historic Preservation Act. You'll learn about legislating at the federal level for the public good, and that's constitutional basis. Later in this section, you'll see how preservation evolved on two fronts: protecting archaeological and natural resources at the federal level, and protecting historically significant sites and buildings at a more local level. Advocates interested in saving cultural and natural resources would eventually reach a kind of you got your chocolate and my peanut butter type of combination law, starting with the National Historic Preservation Act. In the previous section, I addressed the American preservation ethic and where that came from the Washington Slept Here sites to the Mount Vernon Ladies Association, and I also defined other heritage resources. But in terms of preservation law, you need to go back much further than Washington. In fact, we want to go back in time where preservation law started out with pigs and property rights. So let's start with a few ideas about property, where property rights and the idea of private property come from. Ownership and control of property are important in regulating cultural resources in terms of how far preservation laws can go to protect cultural resources. Private property rights limit how much governments are allowed to regulate land use, and the distinction between private property and government-owned and controlled property is going to be significant when we get into federal laws. Let's start with the question, what is property? The word property can mean a few different things in law. It can refer to real property, which means an interest in land, real estate, or the improvements on it. Improvements are buildings or fences or pools or other type of man-made things that people put on property. There's also personal property. Sometimes this is called personalty, which is everything else. This means things like objects. In the preservation context, this might be things like sculptures, paintings, and sometimes artifacts. Property ownership comes up in historic preservation law by way of contested ownership or restrictions on use. Contested ownership is usually about things rather than places. So artifacts, artwork, sometimes human remains, even paleontological remains. For example, there are contested ownership issues surrounding artwork that was looted during World War II, and it's now being repatriated. Lawsuits have come up about this, brought against museums and auction houses. There have been disputes over Native American artifacts. For example, masks that were sold by members of a tribe who had no authority to sell them, because the actual ownership of those masks, and therefore the right to sell them, was with the tribe. Contested ownership with Native American artifacts and even human remains has been so problematic that we have a law that defines who objects belong to. And that's the Native American Graves Protection and Repatriation Act, which you're going to learn about in a later section. There's even been a case where a Tyrannosaurus rex skeleton taken by an American from Mongolia was considered cultural property and had to be returned, resulting in some pretty severe penalties for the man who dug it up. And of course, there's a classic case of the Elgin marbles, where there's the argument between the British Museum and Greece over the return of these works of art. You'll learn more about contested ownership later in the semester when we go into more detail on archaeological resources and Native American issues. Beyond issues of ownership, there are questions about what we can do with the property we own, who can take it, and when, and what others can do with it. When, for example, is the government allowed to take property by eminent domain? Or how many restrictions can be placed on your property before, in a sense, it's not your property anymore? Because we own property as private property, because we have property rights, governments are limited in what they can tell you to do and what you can't do. And that includes limitations like easements, or zoning, or historic preservation laws. It's also where takings comes from. They all stem from our right to hold property, private property. If you wanted to really go into the history of private property ownership in the United States, you could look at the writings of William Blackstone, talk about the philosophy of Hume, or look at the Magna Carta. But in the interest of time, let's just look at the ideas of John Locke, a 17th century English philosopher and the father of classical liberalism. Locke was a major influence on other philosophers like Voltaire and Rousseau, and also on the founding fathers. You can see John Locke's fingerprints all over the Constitution. His philosophies on everything from religion to property or relationships with Native American populations all make their way into the United States law. Locke wrote about property in Chapter 5 of his second treatise. Take a few minutes to look at the language from the second treatise, and then we'll be right back.